Good morning to all of you. I am Sajid Kashrai, Dean School of Legal Studies, UP State Institute of Forensic Sciences, Lucknow. It is a flagship institute of UP government with Namaskar, ma'am. This institute has a focus on forensic sciences. This institute has three schools: the School of Legal Studies, the School of Forensic Sciences, School of Science and Technology. We run 5 courses: BSc LLB integrated 5-year course, LLM in Criminal Justice, BTech 5-year course, and BSc in Forensic Science, MSc in Forensic Science. This institute is headed by Dr. G.K. Goswami ji. He is an IPS officer of UP cadre, and he is heading this institute as director. And he is an world-renowned name in forensic science. He has done too much studies on forensic science. Today we are here to celebrate World Human Rights Day. As we know, from the very beginning of human civilization, basic human rights, which are must for the dignified living of any Homo sapiens, are being protected by some way or other. In the starting, it was protected by the muscle power, and now in civilized days, it is protected by law. Previously, our all knowledge was stored in stones, leaves, cloths, etc. Nowadays, all knowledge, all information is stored in data. Hence, it is very pertinent to discuss that how in the today's age of data, one can protect his human rights. For this, we have a very rich panel of distinguished legal luminaries today with us, Professor Manoj Sinha ji, Vice Chancellor, NLU Jabalpur, Professor Preeti Saxena ji, Vice Chancellor, NLU Shimla, Professor Anju Wali Tikku ji, Dean, Faculty of Law, Delhi University. On behalf of UPSIFS, I welcome you all participants and panelists. Without taking more time, I would like to hand over the panel for further discussion to the moderator, Dr. Abhishek Dikshit ji, our young faculty, to continue the Dr. Abhishek, please.
Thank you, sir. Good afternoon, ladies and gentlemen, and respected panelists, sir and ma'am. It is my absolute privilege to welcome you to this distinguished panel discussion on the topic From Data to Justice, Emerging Challenges to Protect Privacy Rights, organized as a part of our celebration of World Human Rights Day. First, I extend a warm welcome to Professor Manoj Sinha, sir, a celebrated legal scholar with a profound impact on the realm of human rights and international law. Sir is a visiting professor at the prestigious Raoul Wallenberg Institute of Human Rights in Sweden. And sir has been a pioneer and started a post-graduation human rights course in India. And I believe Professor Sinha's insights today promise to be both enlightening and inspiring. Next, we are honored to have Professor Preeti Saxena, ma'am, stalwart in the field of human rights, with over 3 decades of teaching experience and a tenure of 15 years as Dean of Department of Human Rights at Babasaheb Bhimrao Ambedkar University, Lucknow. Professor Saxena has shaped the academic landscape in this domain. Her contribution to the UGC Learning Outcome Curriculum Framework and her extensive publication, more than 50 publications on human rights articles and including many of the books have on human rights specifically, have established her as a leading voice on the complexities of human rights and rapidly changing world. Finally, I introduce Professor Anju Wali Tikku, ma'am, a scholar whose work transcends from traditional academic boundaries with a career enriched by her contribution as a visiting faculty at Jamia Millia Islamia, Indian Law Institute, and Delhi Judicial Academy. Professor Tikku, ma'am, has enriched legal education nationwide. She has written multiple articles and multiple books, and interestingly, a book on on the today's panel discussion theme, a book titled "Right to Privacy in the Information Age." Beyond academia, her instrumental role in assisting the
whether I'm able to relate to it or there is total distrust generated because of the way the justice is being delivered. So when you raise this Sushant Singh's case and you're talking about privacy, certainly. In Justice Puttaswamy's case, we understand that they talked about the 9-judge bench, talked about, and Justice Professor Manoj Sinha would be the right person. I thought it would go the other way around, that he would first talk about the constitutional provisions and then it would come back to me. From a criminologist's perspective, when we are talking about justice, it's all about what is the perception of a victim. And increasingly, we are not only thinking on the lines of retribution, but we are thinking on the lines instead of reformation and restoration of it. So when we are talking about public justice, it is restoring the faith of the people in the governance. So if we look from that standpoint, when does social media have a role to play? How it comes into the picture? Because the understanding is our criminal trials take longer times and it takes almost months together before the charges are framed, before the investigation is completed, so that the people feel they are left to fend for themselves. And that's where the social media, which is considered to be, media as such considered to be the fourth pillar of democracy and governance, pitches in, and keeping in mind that nowadays each one of us is too much interested and indulging in social media. This is how a narrative or a momentum is generated, thereby pressurizing the courts. And there is a very fine line. Every individual is a human being, be that a judge or a legislator or you and me sitting here in our academic positions. We do get impacted by our social environment, and law is certainly applicable not in vacuum but in the social environment. So when we talk about public justice, we need to ensure that even though there are lot many arguments and counter arguments being floated around and lot many cases, lot many information about individuals involved in a case are floated across, until and unless that is authenticated, it should not make us get swayed away with the public perception. Certainly, social media does impact privacy issues. And if I might relate it with wrongful conviction cases, we do understand that that's not only the role of social media, but there are a lot many other factors also wherein people get wrongly implicated, even convicted. So when we talk about social media and understanding and appreciating that it has a huge role to play with reference to dispensation of justice, my privacy as an individual, not only as an accused and a suspect, but anyone who is asked to come in the witness box, who is required and requisitioned and ordered to come over, his or her privacy gets certainly infringed. Privacy is not only my physical privacy, privacy of my information, privacy of my body, certainly we all understand as a component of Article 21, but Justice Puttaswamy somewhere extended and expanded onto that, saying that it's not only bodily integrity and autonomy that we are talking about, it is about information that I happen to have, the choices, the kind of choices I make, the kind of decisions I make, what is my freedom. So it has got three basic components. One is the liberty component, another is the dignity component, and the third one is my autonomy component, wherein we do talk about privacy. So I believe I'll just stop here because this is going to be a very long drawn perception or background being created, that when we talk about social media, it does impact me as an individual, not necessarily as the person who's there in the witness box, but anyone else who is somewhere or the other implicated, accused, suspected through the role of social media, that somebody called someone, somebody sent a mail, so that there is some sort of complicity being generated. And we do also understand the recent cases of whether it was Sushant Singh's case, or for that matter, within that, the kind of people who got involved through social media, that all this is there available on the dark web also. So there's no end to it. Privacy certainly gets infringed, and we need to tread a very cautious path whenever we are dealing with social media, and before we make a considered judgment and opinion as to whether an individual is really a suspect or not. I'll stop there.
Thank you, ma'am. Now I'll move to Professor P. Saxena, ma'am. How do the emerging technologies like artificial intelligence and machine learning affect the era of privacy and digital age, ma'am? Like they're including every walk of life, AI and machine learning. Over to you. Mic is off, ma'am. You're not audible.
Madam, you are on mute.
Ma'am, your mic is
Thank you, Dr. Abhishek, and good afternoon to my esteemed colleagues, Madam Tikhu and Sinha sir, and all the participants here. The question relating to the traditional understanding of privacy rights and the emerging technologies. We know that right to privacy is a declared human right under Article 12 of the UDHR and Article 17 of the ICCPR, with an only difference that in Article 17 of ICCPR, the word unlawful interference is also included, which is missing in UDHR. As we know that we are in an age which is driven by data, using artificial intelligence and machine learning, where we know that every interaction that leaves a digital footprint. And the task for safeguarding the privacy, that has also emerged as one of the most critical challenges of our time. Rightly told by Madam also in reference to the social media, and this AI and machine learning is also being used there. So these technologies, by their very nature, they demand a vast amount of data to function effectively. The LLM procedure is being followed, the large data mechanism. So we live in an era where our lives, whether it's our social life, our economic life, and our personal life, they're all increasingly, we can say, defined by digital interactions. You can see this plastic money at the roadside now. So every aspect of the life is being driven by this data and digital interactions. From the biometric data we submit for the government services, to the information we share on the social media platforms, the data permeates every aspect of our existence. This is very clear. So while this digital revolution offers unprecedented opportunities for the efficiency and innovation on the one hand, it also poses grave challenges, very rightly questioned you from me, and particularly when it concerns with the individual privacy and at the same time the equitable administration of justice, because the journey from data collection to ensuring justice is very, very complex issue, particularly in a diverse populist democracy like India. And as our society becoming increasingly digitized, the need to protect privacy that has gained paramount importance also in today's scenario. So, in reference to shape our discussions around human rights, individual liberty, state power, and justice, coordination is very important, because we know that right to privacy is a constitutional pillar, and very rightly told by Anju ma'am that the judgment of K.S. Puttaswamy, where the Supreme Court unanimously declared the right to privacy as an intrinsic right to not only right to life but personal liberty, because earlier what we were studying from the judgments and the constitutional law books, that the court was deciding or interpreting Article 21 that it's a part of extension of right to life, or it is the extension of right to personal liberty. This is the first case where for the first time the Supreme Court unanimously said that this right to privacy is the part of both right to life as well as personal liberty. And this judgment, we can say, underscored the three key principles also rightly told. Legality, that any invasion of privacy must have a clear legal basis. Then the necessity and proportionality also. So, on that basis, if we say that we have to face these challenges in an era of the technology and the use of the artificial intelligence and all that, so we need to talk about the privacy in this data driven world in reference to the India's digital transformation. Not leave the digital transformation. This is a need of the day. But we know that this has brought many things on the basis of which the data is being collected. It's Aadhaar, the world's largest biometric identity system, to the digital platform, to the personal data. So all this has harvested and we can say processed at an scale. Now, what we are facing is the data vulnerability, because high profile breaches such as the leak of the Aadhaar that exposes the citizens to fraud and misuse and thereby violating their privacy. Then at the same time, you see the consent deficit is always there, because if some physically what's your name, and if I'm not knowing that person, why should I tell my name? But if see, if it is on the social media or somewhere, then everybody, if there is a form you are working, or if the site you are surfing, then if it comes that you have to fill these columns, and you without asking and start continuing filling all these columns. So without the consent of these things, that many individuals, they are not aware to what extent the data has to be, extent the informations are to be given. So sometimes this consent deficit is also big challenge for the right to privacy of the person concerned. And then surveillance also, because we are not having all these things which the other developed countries are having, like face recognition, etc. But still, government and some surveillance have raised some alarms about the mass data which is collected the adequate safeguards. Though it may be used or not, because it is said that it will be used for the benefit purposes of the person, but there is a deficit of the consent of that person, that where that use informations are being supplied on the basis that the government is demanding, because we are freebie and all these things are running. So in that way, how much privacy has to be uphold of the citizen, of a common man or an individual, this is one issue. And on the other way around, we can see that the government is also one of the great, we can say, the authority where we are giving or we are submitting our data. So in that, a balance is very important. And on the basis of the collection through the use of the AI and all that, we have to have certain, we can say, emerging challenges, as you have rightly pointed out, to the privacy rights, because we have the Digital Person Data Protection Act of 2023 that aims to regulate the data usage, etc., etc. But if you go the entire provisions of this act, then you'll find that there are certain lacuna which are not protecting the rights of the person, the privacy right particularly. Unlike you see in the GDPR, in the European Union, the India's framework need to have certain robust protection or independent oversight, considering in view that we are having the existing GDPR and we have not taken clue from that while we have made. And this is, you must be aware that this is the fourth iteration of the data protection that has come to in light with an act in 2023. So the draft was something different, and the act came that was entirely different. So these are also issues that we don't have the data protection framework which can, protect the privacy rights. Then the corporate data exploitation is always there, because we are living in a country where there are tech giants and the data brokers also. They collect, they analyze, they monetize the personal data. And there is a negligible transparency in that, because if we find that if these things are to be transparent, then one can be aware that what information he or she is being giving to these corporate sectors also. Then if it is a case of the AI and the machine learning, artificial intelligence and machine learning, we all know that this AI works on the algorithmic biases, and there is a big difference between Ali and Ellen, because what we feed, that comes out to us, and what is being fed, that is the human being. So what they are doing, that is impacting the privacy right of the person concerned, and that affects their economic rights, that affects their employment, that affects very other rights, which has a direct impact on their privacy also. So in that way, the point here is that we are using the AI and machine learning, but there is a great challenge to protect the privacy in this challenge, in this era of this technology. That's my take on this question.
Thank you, ma'am, for your insightful words. We'll be coming again to you, ma'am. Then we'll be moving forward to Professor Sinha, sir. Sir, how has the constitutional understandings of privacy evolved with technological advancements, particularly after, as we already talked about, Justice Potoswamy judgment? So, how has these advancements have taken place into? So, if you can throw some light, sir. Sir, mic. Sir, your mic is off, sir.
Thank you very much, Abhishek. And I think the question which you posed to me already extensively answered by Professor Tiku ma'am and Professor Preeti Saxena. But let me start with saying something. If I take the help of Article 8, European Convention on Human Rights, more or less that is mentioned under the Article 12 of the Universal Declaration as a Preeti ma'am, and also 17 Siemens. So a close reading of the article, what it says, that private space of the individual, private space of the correspondence, these are the protected there, and state has no right to interfere in the private sphere, and that is the way almost all convention in a very limited. But these conventions, these instruments were drafted in era where internet was not there, where technology was not there, and but even the constitution, if you look into the constitution, so all are in the early late 40s and early 50s. We find evolution of the human rights, categorization of human rights, and of course a human rights right to private space has been duly recognized in the human right. So everyone has the right to respect for his private and family life. So I see the country, like I see more on the left ideology or communist. When a country where people are on the street, there is no home, there is there's no correspondent, no place to sleep. So everything is open in the world, and 60 to 50% worldwide populations are in extreme poverty. So what I say, and in fact I shared with a judge also, that the concept of right to privacy is more an elitist concept. It's a more, think about the people who discuss, the people who decide, and the people who implement. All are in a position of power. They are in a position to talk about the privacy. So it benefits largely to the upper sections of the society, and we go to the court, we challenge, we feel that defamation, privacy has been violated. So it's a concept we have to make a distinction. It doesn't address a large number of a poor person. If you ask, he will say, state always comes with an argument, and that is also in the constitution also, about when we talk about the article 19(1)(a), freedom of speech and expression, or people, even article 21, we say there are a lot of restrictions some way, which Puttaswamy case also acknowledged. They said that there are grounds where this can be, there's a possibility of state interference. So the major three, if I take note of Professor Tiku ma'am, and she rightly pointed, and ma'am also, about the responsibility of the state, that who will protect your right to privacy, and who violates your right. It violates by the state. State is the protector and state is abuser. So state has to, like, say, the state is not required, state is not going and looking into the what Puttaswamy judgment. Otherwise, the misuse or abuse of Section 66A of the IT Act would have not happened after the decision of the Shreya Sehgal. In fact, Justice Nariman, he came to know that after his decision, there are more than 600 cases were filed. There are more 600 cases. Yeah, it has gone. Second. So 600 cases have been filed in that particular uh, in a situation. So he was almost surprised how things have taken shape. Like, enforcement becoming a major issue. Enforcement becoming a major issue. The court given a judgment, and surprisingly, ma'am, like, even 2-3 cases were registered from Delhi on that Section 66. It's not the only police, also the magistrate. Both are equally, like, they are, so people are not aware. So we give too much importance. We miss the practical aspect in the challenge in the privacy. So I see that privacy has, like, Puttaswamy and even Aadhaar judgment, it made quite clear that school and colleges should not ask about the Aadhaar number. But still it continues. And we accept that one. It's not, it should be optional. But even, like, for the university, for the remuneration, sometime already they said ki Aadhaar number, your PAN number. So what if we practice and what we the code, we think there's a, like, huge gap. That is the major challenge which we see about the constitution. Of course, constitution, and then court, the Supreme Court of India very correctly pointed out in the case in case of KS Puttaswamy, privacy is a constitutionally protected right which emerges primarily from the guarantee of life and personal liberty in Article 21 of the Constitution. So that has been well elaborated in Puttaswamy. Even this case, if you go back, why this case became a 9 judges bench? Because you have 3 different judgments, and that is the major concern I feel. Every 10 years, 15 years, so there is a lack of consistency also in the judgments of the Supreme Court. What judgment you will pick? Like, recently the private property owner versus state of Maharashtra case. So there are series of judgment, different things are coming up. So court they have a home, they have a private correspondence, they have a mobile. Their right, also this right becomes relevant for them in days to come. Over to you, Abhishek.
Thank you, sir. A very insightful comments and mentioning a lot of cases. So it's for us also and students also to read them, sir. Now I'm coming back to Anjali Tiku, ma'am. Ma'am, I was just wondering, like the artificial intelligence is like, this lot of technology has improved in the homes and every walk of life, phones, even TVs, smart TVs. So can even food are coming, automatic machines are coming up. So can privacy be ever be absolute? Obviously, we know about reasonable restrictions in the mentioned in the constitution, but can the level of privacy which the Indians are, the needed and it's technology in every walk of life. So can privacy
Thank you, Abhishek, for that question. And I believe I'll just make two statements rather than one statement primarily. We have Professor Bakshi's article wherein he has categorically, the title is From Human Rights to the Right to be Human. So that is what Professor Sinha was saying, and that is what Professor Preeti Saxena ma'am also highlighted in her statement to your question, that there are huge challenges with reference to every aspect of our existence. We are privileged enough to talk at this platform, through this platform, but there are people who do not have two ends meal to survive. So when we are talking about privacy, so people on the roads, it appears, do not have any right to privacy. It is meaningless to them. So when we are talking about whether privacy can be absolute or not, with that background, we need to understand. And specifically in today's era, when we have got through artificial intelligence, through rather technologies, not necessarily artificial intelligence, that's just one component, but through the advanced technologies in every sphere of life, when the sovereignty of a nation is at stake, can we think on the lines of privacy to begin with, and that absolute privacy? With reference to that, my clear response would be a total no. We cannot argue on the lines of privacy, and that is further substantiated by the fact that we have our own legislations. We have got our procedures in place, wherein, as rightly pointed out by my two co-panelists, we are compelled to provide our information. We just do not want to, but then we have to provide our PAN information, we have to give our Aadhaar information. Otherwise, we will not be able to proceed further on any online transaction. Forget about that. Even with reference to we, the government servants on the panel of the government, we do not get our salary. We have to give our PAN number. Everything is connected. Every information is there with the government. There would be lot many private transactions wherein we do not want to reveal those transactions by way of abundant caution, securing our rights as to what transaction I am doing at a given point of time. So there are always competing interests. So when we talk about, say, income and salary, there are people, the business class, who are not giving any information. They have that right of privacy. They're able to maneuver. I'm not saying manipulate, they're able to maneuver. And tax avoidance is permissible. Tax evasion is not. So there are always those pros and cons. There would always be parallel illustrations wherein we can raise our eyebrows that why this is happening and why that is not happening. Now, when you talk about absolute privacy, again, starting off and taking off that no, there cannot be a concept of private privacy which is absolute. We do have another legislation. It's not only DPDP Act. We also have got another legislation of 21, which was enforced in 2022, when we talk about Criminal Procedure Identification Act. So if a person is accused of having committed any offense against a woman, compulsorily he has to share his data, measurements, his blood samples. So all kinds of biological samples can be mandatorily retrieved. So where is that privacy? So by law, privacy is being taken away in certain situations. Why? To ensure justice, public justice. And that too, when we talk about justice, justice would be meaningful if only we are secure in our own nation. So, whenever there is a challenge to the national interest, national sovereignty, privacy cannot be flagged as my absolute right. I'll stop there. Thank you, Abhishek.
Thank you. Thank you, ma'am. Thank you, ma'am. We are running short of time, so a very quick question to Princess ma'am, and then last question to Manoj sir. Ma'am, a very interesting question and very intrigued, and this question shake the whole premises of our panel discussion also. That coming to the digital divide that India has, and many other problems like the right to food and all those things. So we are discussing about right to privacy. So a very pertinent question that comes to our mind that in a country like India, should privacy be given that much importance over to some basic human rights, ma'am? So that is a question to you, ma'am. Thank you. Ma'am, Mike.
Thank you, Abhishek. We know that a significant portion of India's population that lacks the awareness and the tools, as you are talking about the digital divide, the tools to understand privacy risks. They are not aware. They cannot assert their rights in the digital ecosystem. We all know, but privacy right, as I think that it must be protected for all the citizens, regardless of their whether they are having the access to the technology or not, because we not need to ensure that justice, as Madam rightly observed. And in that way, what we are doing is that in this era of digital divide, as we can say also, we need to ensure justice because it is not reserved for the digitally privileged person. This is one thing. The second point which I would like to say is that, as you say, that the privacy should be prioritized, it had to be given the priority over the other human rights. So I would say that protecting privacy is not just a matter of the individual human rights or to give the priority over the human rights, because Article 12 and Article 17 of the UDHR and ICCPR, as I told you, it is basically linked to the broader issues of the social and economic justice. And there is no hierarchy of rights of the human rights. Every right is equal. So there is no question of giving the priority over privacy to the other. So I would say that there is a need to make a balance, as you rightly questioned to me. But there is no question to give the priority of privacy over other human rights. And I will be following the points which have raised by Madam Tiku, that in the system where we are living a social welfare system, it is the state who has to protect the right, but at the same time, individual right must also be balanced with the public rights, and in that way, this privacy cannot be given the priority. This is my point, and we can have to balance required between the human right and the privacy right, which is also a human right. So we need to promote the digital literacy, because there is a digital divide. The persons, they are lacking or they are not aware about all these things. We need to promote the awareness in the persons, that they may be aware as to what are their rights and how they can ensure the data minimization or data anonymization. This is very important, which we can define in way of the privacy rights. But otherwise, we need to encourage the use of privacy, which can preserve the technologies, and encryption we can use, decentralization of the data storage system we can use, because if you see DPDP Act, then there is nothing like that. So we can go for all these things, but at the same time, as educators, as legal professionals, it is our but that has to be in the cornerstone of the justice as a whole. Otherwise, there is no point of giving the priority. Thanks.
Thank you, ma'am. Sir, a very quick question to you, the last question for the day. Sir, do you think the existing legal frameworks in India are adequate? Because we see various events also, Pegasus, Spygate software issues, and many other issues in the news only, sir. Do you believe the existing legal framework, even after DPDP Act or Justice Portoswamy judgment, so they are adequate? Though we have discussed a lot about it, but want your concluding comments on it, sir. Like, and what the way forward for India to discuss about the privacy challenges to privacy, sir, these days. Sir.
If you want just one word, I'll say inadequate. So inadequate. So there is no doubt of legal framework like it's not adequate, and we all have emphasized. And in fact, the technology, because it's not in matching with the pace with technology development. So every day prime minister. So I see one thing: right to privacy is a human rights or fundamental rights, no doubt, and it's very much linked with the dignity. If somebody will ask, no, आप ये बताइए आप कितना कमाते हैं, so you feel hurt. So it's some way linked with your right to dignity, with like as a human being. So personal information we don't want to share. So it's a very important right. Right to privacy means one should respect. This is line, Lakshman Rekha. So we should not go on the private discuss things or something. So it has a element of dignity of the individual. So if you travel abroad and you go to the French embassy, they take all your fingerprint like you are thief. You are going and you feel very humiliated. But the charm of going abroad is always so much. You compromise your dignity. Many times you feel, the way immigration officer look at you, your passport, it hurts you. So it's like, Indian or Pakistani. So the way they treat or something, it touch you, and they even information is there, but it hurts your dignity, and that is the important. So it's remain a very fundamental human rights, and that is the reason it has been linked with the Article 21 of the Constitution, and says life and personal liberty, that dignity is there. Just to sum up, the laws are inadequate. Even laws are developed, it takes many years. By the time new technology comes, like artificial intelligence, Professor Preeti mentioned that machine learning. So we are not catching up. So we have to think, and this is not the problem we are facing. It's a global problem. Abhi European Council of Europe has done Convention 108. They have modernized. So they keep on working. So we have to also be very alert. A dedicated department, IT or something, given this task to how to revise, how to modify. If we do, then there is a possibility we can catch with the development which are taking place.
Thank you, sir. Thank you, ma'am.
Law cannot catch the pace of technology.
That's a challenge.
That is a challenge. Just a concluding remarks, and then our assistant professor Nikita will be giving a vote of thanks to the professors. So, just as my understanding of the article Professor Lakshman shared on the judgments that have been discussed today, so we got to understand that human right cannot be a static principle, but it is a living testament to our collective values. So, because we are running short of time, I'll be briefing my concluding remarks, and then I'll giving it to Nikita for a short vote of thanks, and then we'll be concluding this panel discussion. Thank you, ma'am. Thank you, sir, for coming and joining.
A very esteemed panelist, and a very enriching this lecture was today. I myself am assistant professor, ma'am and sir, at the UPSIFS. So starting from the Anju ma'am, what you have ma'am said, it really connected with us. The three basic components of our human rights, the liberty, the dignity, and also my autonomy, and how it is being protected, and what are the challenges of this era, of the digital era, to protect my own liberty. Also very rightly said by Preeti ma'am also, that every interaction in digital domain leaves a footprint, a digital footprint, and how to protect it is a major challenge. Also very rightly said by Manoj sir, respected Manoj sir, that enforcement, at the end of the day, the enforcement is the major issue. So thank you so much, ma'am and sir, for your enriching experiences and for taking out time from your busy schedule to be present here. I would like to extend my thanks to Professor Preeti Saxena, ma'am, Honorable Vice Chancellor, HPNLU Shimla. I would also like to extend my vote of thanks to Professor Anju Wali Tikku, ma'am, Dean, Faculty of Law, University of Delhi. Also, Professor Manoj Sinha, sir, we have had interaction 2 weeks back also at the Constitution Day at UPSIFS. So, Honorable Manoj Sinha, sir, thank you so much, sir, for being present here. And also to end our discussion, this such an enriching discussion, to end it on a lighter note, I would like to end it with the quote of with the quote of Nelson Mandela. He has very rightly said that to deny people their human rights is to challenge their very humanity. And our today discussion of a further domain of digital footprint and how to protect privacy in digital era leads to that. Thank you so much to the panelists, and thank you so much sir, for such kind moderation also. Thank you.
Thank you.
Okay, thank you.
Thank you, ma'am. बहुत थैंक यू
बहुत बहुत धन्यवाद सर, बहुत बहुत धन्यवाद, और आपको बधाई दी इन पर्सन ऑनलाइन।
थैंक यू मैम।
जी 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 सर,
फिर आऊंगा, मैं मिलूंगा आपसे मैम।
जरूर जरूर जरूर, उम्मीद है।
थैंक यू।
जी जी जी।
Yeah, thank you, Vincent.